Namaste, my name is Pranav, and in this I belong to Faculty of Non-Governance, and in this session I am going to continue the feminist legal theory. So till now we have seen the inception of feminist legal theory, what are the various methods of methodology of feminist legal theory, subjects of feminist legal theory, and we have studied the identity problem. Now we are going to study about difference arguments, and afterwards we will try to, if at all we have time, we will try to uh, learn about different waves of feminist argument. So let's start with the difference argument. The feminist argument in identity issue tries to establish their identity. What is their identity? They have no identity, and it is all their struggle to establish their identity. Now, in difference argument, I want to take a very important name, the name of Carol Gilligan. So, Carol Gilligan came up with her work in 1982, and the name of the work was In a Different Voice. Now, the Gilligan and others of her school argue that men and women have different ways of viewing this world, conceptualizing moral problems and approaching the relationship between oneself and others. The men and women essentially have different values and different ways of relating and reacting to others around them. Men act and interact on the basis of an ethic of justice which relies heavily on rights and abstract justice, and which is based on the premise that everyone should be treated in the same way. Women, on the other hand, relate to others on the basis of an ethic of care, premised on non-violence, that no one should be hurt, and focusing on responsibility and contextuality. Now, the ethic of care is an essentially female value because it stems from the capacity and the process of reproduction, which is an exclusively female experience. Now, difference principle difference principle focuses on law in a patriarchal society, and it has two prongs: the male ethics of justice and the female ethic of care. The male ethic of justice consists of separation and exclusion, the logic of justice approach, balancing of abstract rights and duties, individual achievement, selection of winner, and this ultimately results in gender oriented injustice. Now, the female ethic of care is of attachment and inclusion if you compare with separation and exclusion, and it includes conciliatory alternatives. It includes tender of care and nurturance. It includes collective responsibility, and it includes ultimately the ethic of inclusion. So the problem today is that in all patriarchal or male dominated societies, the legal system and the law mainly reflect the values of their male members. And in all such societies, damage to the continuity results from the law's failure to incorporate those values associated with women, especially the female values of intimacy, nurturance, responsibility, and ethic of care. Even if you see today, What all institution do you have? Education institutes, government. You will find that there is a lack of these values, that intimacy, nurturance, responsibility, caring. And a positive change in the law can only be achieved by incorporating fully the relevant female values into the structures, processes, rules, and principles of the legal system. This will result in a fundamental transformation of the very essence of law, making it possible for both women and men to enjoy the fruits of a socially balanced law, which would otherwise have been denied them. Now, uh, there is this person, Irigare. Irigare questions equality to what? What do women want to be equal with? Men? A wage? Why not themselves? So, other feminism of difference have emerged from French feminism. So, Irigare insists on women's difference from men. She argues that the prevailing model of the self and the legal subject is based on an account that, while it considers itself to be neutral, it is in fact a masculinized model. The differences are not only described in terms of culture but are also related to women's bodies and morphology because of what she considered to be the irreducibility of sexual difference. The question of equality is no longer appropriate. Hence, equality to what? What do women want to be equal to? Men. Instead of attempting to a balance of law for all through an ethic of care, Irigare would like us to define at least two sets of parallel rights and duties relating to each sex. This is a deeper challenge, if you look closely, to the whole of our culture and social order because it not only recognizes differences but for the first time allows women to become fully fledged subjects in their own right. Now, with this, let me try to focus on various other prongs of feminist jurisprudence. So, a number of schools of feminist jurisprudence have emerged, each stressing specific principles of inquiry and models of investigation. So, the first one is liberal feminism. So, the liberal feminism emphasizes the need for a concentration of activity on equal rights and opportunities and the heightening of constitutional rights. The principle of this school of thought is the extension of rights by building upon a stratum of rights which have been won. Whatever formal barriers are preventing the full participation of women must be removed so that equal opportunity for all might prevail. Now, the after liberal feminism, it is radical feminism that comes into the focus. The radical feminism concentrates on women as a class. Now, as contrasted with the individual women who is the concern of liberal feminist ideology, women's specific problems as workers must be emphasized and an unremitting struggle against the legal ideology which seeks to minimize the effect of these problems must be based. After radical feminism comes cultural feminism. Now it stresses the importance of changing legal and social conditions so as to give equal weight to women's moral voice. Relationships between mother and child and concepts of equality within the family group must be stressed in appropriate ideological controversies. Now comes postmodern feminism. Now, this school denies the value of any theory or equality which seeks to portray women as a group. Now, the different psychological need of women must be reflected in legal ideology and legal rules. Now, Patricia Smith has written very eloquently on postmodern feminist that for postmodern feminist there is no single solution and no single oppression of women, but only solutions tailored to the concrete experience of actual people. And afterwards comes Marxist jurisprudential feminism, which seeks to apply the Marxist canons of interpretation of history to women's problem. Now, these are to be analyzed as part of the wider group of problems arising from women's economic position as workers. And women's problems will disappear only when the class divisions have disappeared. Now, opposition within the feminist jurisprudence movement to alliance with Marxist jurisprudence group has been strong, and Elizabeth Cross, in her essay Marxism and Feminism, described it as the political and institutional power of Marxism is such that any feminism can only be tolerated insofar as it accepts Marxism's fundamental premises and modes of thinking. Now, ultimately, we have come to the end of feminist jurisprudence school. Let me conclude it by saying that the goal of feminist jurisprudence is of good society, which is characterized by any absence of discrimination and inequalities, and it wants to achieve substantive equality. Now, the movement towards the goal involves an unremitting struggle based upon an interpretation of law from entirely new perspectives. Imagine if there were no feminist legal school or thought, then would Honorable Justice Chandrachud have been able to do away with the injustice perpetuated by Sabrimala practices? So, if law stands for justice, it must be justice for all. But the fact is that law has been notoriously bad in providing justice for persons outside the dominant culture. The principles of feminist jurisprudence have been fashioned and must be applied in the name of legal outsiders. Thank you.